The next case to come before the court is Baab versus Medina City School Board of Education. Yeah. Each side will have 15 minutes to present their arguments, and the appellant can reserve up to 5 minutes for rebuttal if you so choose.
Thank you. May it please the court, my name is Maria Perlmutter, and I represent the defendant appellants, the Medina City School District, and Julia Schwendeman, its guidance counselor. We ask this court to reverse the trial court's denial of immunity, and I'd like to reserve 3 minutes for rebuttal. The facts giving rise to this lawsuit are tragic. In November of 2012, plaintiff's 14-year-old son took his own life. But this horrific loss is not the fault of the school district or its guidance counselor, and because failure to prevent a suicide does not cause it, these defendants should not be subjected to a lengthy and resource-consuming litigation process. They are immune. And in fact, immunity is at the very heart of this matter because there are 2 separate Ohio Revised Code statutes granting immunity to both defendants. First, we have Chapter 2744, which is Ohio's political subdivision liability laws, and these generally protect school districts and their employees from personal injury lawsuits such as this one. There are several exceptions, of course. One of the exceptions relates to claims for which the Ohio Revised Code separately and explicitly imposes civil liability. Plaintiff takes this exception and asks this court to expand it to cover his circumstances, but it doesn't fit. The exception does not apply. Specifically, plaintiff argues that Ohio's child abuse reporting statute 2151.421 required Julia Schwendeman, the guidance counselor, to immediately call Child Protective Services and report child abuse after she spoke with an unnamed woman, a Jane Doe, from the community who called her and speculated and theorized that perhaps plaintiff's son was being abused. And plaintiff argues that because Julia allegedly didn't do so, because she allegedly failed to make that phone call, she loses her immunity, and the district as well loses its immunity. This argument fails for 3 reasons.
Before you go, and I want you to keep your train of thought, but as I read the court's opinion, the court doesn't discuss immunity. It talks about 12B, just a motion to dismiss. How do we know that the court, theoretically, that the court considered immunity?
And certainly we briefed this, I think at least once. Immunity is an important factor here, and 12B is intricately tied in with immunity. I'm reviewing a motion to dismiss. Of course, this court must accept all allegations as true, and although the district certainly disagrees with the allegations in the complaint, for the purpose of this appeal, we accept them as 100% true, as this court must. But the court does not read into the complaint facts that are not there, facts that are not pled, and that's why this our 12B motion should have been granted. This complaint should have been dismissed, and part of the next reason is that there's no allegations of reasonable cause to suspect abuse listed in this complaint.
Was anything else other than immunity argued in the motion to dismiss?
Yes, in the motion to dismiss, we also argued that there's no causation. This is a wrongful death, and causation is critical. Direct causation is critical in evaluating a wrongful death claim. We argue that the plaintiff's complaint does not suggest that those facts exist. But on an appeal, we address only the immunity, and there's 2 separate statutes. So even if this court...
Well, here's a follow-up with Judge Moore's question. I think you're responding, and I could be wrong, but I think you're responding more to her question from the standpoint of a final appealable order. And maybe what Judge Moore is saying, and I don't mean to put words in her mouth, but
maybe what she's saying is, how do we really assess this? Because the court hasn't even assessed the immunity. How do we know the court, it's not just a final appealable order issue, but you filed a motion to dismiss on the basis, like you said, a couple things, but a 12b6 is failure to state a claim upon which relief can be granted. And the court said that you were not entitled to a dismissal on that basis because I'm going to take all the facts as true, and that states a cause of action. Okay? But the court didn't specifically say, although it may state a cause of action, the city has raised an immunity defense, and they haven't laid out anything in the complaint that gets them outside of the immunity defense.
And when we briefed this, I think plaintiff did file a motion to dismiss the appeal. We responded, and this court determined, and this court denied plaintiff's motion. And
But I'm not talking about, I'm sorry for interrupting you, but I'm not talking about final appealable order. I'm talking about, forget about final appealable order. I'm talking about the court doesn't analyze immunity at all. Are we supposed to analyze immunity for the first time ourselves?
immunity is critical here because immunity is effectively lost if these defendants are.
And I understand that. I was a civil division prosecutor. I argued it, who knows how many immunity cases. My point is, we're a reviewing court. Nobody's talked about immunity at all yet in the trial courts.
I think immunity, because it's such a central question, is first of all implied in the court's denial of our dismissal motion, and also because it's such a central point, we cannot continue without asking for an appeal of it. We cannot continue without asking for a review because we're essentially then in the position of allowing the system to drag our clients through this process and for all intents and purposes denying them this immunity.
Well, and even file summary judgment.
Yes, but there's definitely Ohio case law suggesting that if you don't appeal immunity at the very first step, it could be waived, and we didn't want to take that risk.
We could also remand it to the trial court, and we've done this in situations where the trial court has not given us enough of an analysis in its opinion for us to review the issue.
Absolutely, and I think that although that would be an appropriate outcome, I think a better outcome would be if this court did take a look at the actual complaint and overruled the denial of immunity. Because again, remanding it to the court and going through the process again it takes longer, and although it doesn't destroy immunity, it certainly subjects our clients to the continued litigation process.
But on the other hand, you have plaintiffs that are entitled to their day in court too. So we have to be careful about all that.
Absolutely, and as you mentioned, Judge Carr, if the court would like me to kind of switch over from the immunity argument and talk about 2305.51, I'm happy to do that, or I can continue on the immunity part.
Well, I'm sorry, we just need to get some of these
That's fine.
procedural things, but did you want to reserve some time, you said?
3 minutes.
Okay, that's fine. Go ahead, you go ahead and argue whatever you want to.
Okay, so even if this court disagrees and finds that an exception here applies, we're arguing that there's nothing in the complaint showing reasonable cause to suspect abuse. There's an allegation the child came into school with welts and bruises, but even if this court disagrees and finds that the exception applies, the analysis, of course, does not stop there, because 274403 lists defenses that if they apply, it reinstates immunity, and one of the defenses is a discretionary act, a judgment call, because the legislature understood that political subdivision employees must have the freedom to take discretionary action, to make judgment calls without fear of legal reprisal, even if the outcome is unfortunate, is not what we wanted. And this is what happened here. When Julia
Well, how do you know, on a 12B6, how does the school district demonstrate that this was a discretionary action?
A discretionary action takes place when there's a judgment call, and we look to 2151.421, which tells us that there's only one obligation, and that is to report when you have an objectively reasonable cause to suspect abuse. And logically, from our experience, when an individual has to make that call, according to the plaintiff's allegations, all we know about the abuse, we don't even know that it happened. We don't even know who the abuser was. All we know is that a Jane Doe called and speculated, perhaps, possibly, this is going on. So when the guidance counselor has to decide, is this enough? Is this reasonable cause? Do I have to, according to the statute, do I have to report this? That's a judgment call.
What about investigating further? What about calling the parents? What about taking further action of any kind whatsoever?
And the complaint, the record here, does not tell us that she did that. And even that's a judgment call, even deciding whether or not I have to investigate further, or if this allegation or if this phone call is something that I should not look into further. That's a discretionary act, that's a judgment call. And
May I ask a question? Was the implication from Jane Doe, which of course we don't know because we got 12 hands, was the implication that the abuse was from the parents? Because then
the complaint does not say that, but there have been articles in the paper that have said that. The complaint, from what I understand,
But that's not
on the record.
Okay, none of that would have been in the record because you didn't get that far.
Right. We haven't done discovery in this case, so we don't know that. So because it's a discretionary act, we maintain that the district's immunity is reinstated. Even if, the important thing to remember is that even if this...
I know you're not going to believe this, but you're starting your rebuttal time.
I'm so sorry.
That's
I will.
the reason we asked a lot of questions.
That's fine. I'll
You
come
say
back to
that?
it.
Morning.
Good morning, you may proceed.
Police Court, John Cameron for the estate of Devin Baab. First of all, just to address something that this honorable court brought up, which is trial court did not address the issue of immunity in any way, shape, or form. It's a very cursory entry. It spells out the legal requirements, but it really has no meat to it. And this court cannot, for the first time, rule on an issue. As was correctly stated by Your Honor, that this is a reviewing court. There's nothing in the record. And that's exactly why it was our position that this was not right, that this was not a final appealable order. There's nothing there upon which to declare it a final appealable order. But as far as my argument, it's really quite simple. I'm a plaintiff. I have to prove a duty, a breach of that duty, and causation. I understand that. Well, here we have two different approaches to the duty. First of all, we have a school counselor who is in a position of authority over impressionable children, and there is a fiduciary duty there, period. Second of all, we have a school counselor who assumed a duty, even if you thought that there wasn't a duty there, when she told Jane Doe that, don't worry, we have this under control, it's handled.
Well, how is that assuming a duty? And to whom? Is it to Jane Doe? Because Jane Doe's not a party.
Jane Doe is not a party. Jane Doe, had she not said that, would have reported to somebody else.
Did she say that in an affidavit?
It's not in the record. I think it's reasonably, I think it can be reasonably inferred, and I'm not going to go into what the papers have said, had she not said that Jane Doe would have carried it further. We're entitled to all inferences.
Jane Doe could have gone to the parents.
No, Jane Doe couldn't have gone to the parents. That was impossible. Jane Doe had no way of knowing who the parents were, did not have a phone number, and couldn't contact the parents.
Wasn't her son a friend of the child?
You're asking me to go into facts that are not in the record, but I will tell you that Jane Doe asked for the phone number and the counselor was refused. Asked for the phone number of the parent.
So none of that's laid out in the complaint?
No. But again, it's notice pleading. So then you have the statute. You have the reporting statute. There's reporting statute's mandatory. It's not discretional. It's not discretionary. There's no discretion in it. It says anytime abuse is suspected, anytime that there's a reason to suspect abuse. Well, here you have a member of the community. We're entitled to the inference that she's a reliable member of the community, that she should be trusted, that this is valid information, that she's a credible witness, who calls up and says, this kid's suicidal, which Webster's definition of suicidal says that there's basically that this kid's going to kill himself, that this kid is about to do serious harm, and that it's possible he's being abused. Possibly.
Let me ask you to back up.
Okay.
You said that she is a credible witness. How do we get that?
I'm entitled to that inference. This is pleading stage. This is.
I understand that, but are you saying that you pled that in your, or pled facts that from which we can infer?
Yes.
Okay.
What we pled was that she was the mother of a good friend of Devin, the decedent, and that she spoke to Devin and spoke to her son, and that was the basis of her opinion. And you certainly can infer from that she's a credible source. So,
Or at least that she has some.
she has knowledge.
She has some knowledge.
Exactly. So you have a school counselor. So we get to the 3-tier analysis. Basically, we start out with the assumption of immunity. And then the second tier is there one of 5 exceptions. And the interesting part about this is this applies to the political subdivision. It does not apply to the employee. It applies to the political subdivision, the 5-tier, the 5 exceptions. And there certainly is an exception to the immunity, which is the reporting statute. As I said before, reporting statute is not optional, it's not discretionary, it says it's mandatory. To read into that a discretionary act totally flies in the face of the statute itself and all interpretation to date. And the statute does not require proof that there's abuse going on. The case law is repugnant with instances where the courts have said that it's really meant to prevent abuse, not to cure abuse after the fact, and that any time there is reason to suspect abuse, it must be reported. So you have the second tier is clearly met against the political subdivision. Then you go to the defenses. Now the defenses actually only apply to the employee. The defenses are not, at least the applicable defense that the employee didn't act with recklessness. And it's our position that it certainly couldn't be more reckless. It certainly couldn't be more reckless to receive a phone call that this kid is about to kill himself, and I think he's being abused, and to say, okay, it's under control, we'll handle this, you don't have to worry about it, and then do nothing. I can't imagine a more reckless act.
Let me ask you a question. Isn't it reasonable for the counselor to think that the abuse Jane Doe thinks is happening was really the bullying at the school that the counselor has been aware of for months? That's what she's been working with the dad with for months with this, or at least a month with this child prior to the event occurring.
Well, the pleadings indicate that she believes he's being abused, or she believes that the child's being abused. And any time that there's a suspicion of abuse, there's a duty to report. It's not the counselor's...
But it's not her belief, it's someone telling her that.
Correct.
So it's not her reasonable belief, it's Jane Doe's reasonable belief.
When, again, we're entitled to all inferences, so we have someone who has knowledge,
Jane Doe,
who appears to be credible and is telling her that this kid's suicidal.
and we don't know what she told her, because it hasn't
Well,
been explored.
We've put that she, again, and that's exactly why at this point in time we're entitled to all inferences and all factual conclusions. So, we have a counselor who is not entitled to escape personal liability, even if this court found that the reporting statute wasn't met, because the requirement, that those 5 exceptions, only apply to political subdivision. So even if this court found that the reporting statute wasn't violated, then there would still be liability on Julia Schwinderman, because she has a duty exclusive of the reporting statute, and she acted reckless. The 5 exceptions only get the political subdivision now. They don't get the employee. They don't.
She doesn't have immunity because she's a mandatory reporter. Is that what you're saying?
No, that's not what I'm saying. Even if she was not a mandatory reporter, she would still have duty. And that's based upon the fact that she had a duty and she breached it, and she did that in a reckless manner. So the defense and the third part of the third tier of the analysis would not apply. That's my argument.
Do you have a motion?
Even if she was not a mandatory reporter, she still had a duty, and what was the duty? Why did she have that duty? In what capacity did she have that duty?
She had that duty as a school counselor. She owes a duty to the students. And I argue that even if there was a question of whether or not she had that duty, she assumed the duty when she said, I'll handle this.
Thank you.
Thank you.
You have just under 3 minutes.
Thank you. Just 2 quick points. First, about Julia Schwenderman and her individual immunity. The exception in 2744.03A6 is for a reckless and malicious employee, for somebody who acts in bad faith. Plaintiff's complaint shows the very opposite. Plaintiff's complaint tells us that Julia called the parent, called the plaintiff, asked to speak with him about his child's mental health issues, then specifically met with him and a teacher to talk about these issues. After the child was eventually hospitalized and released, Julia then called, this is what the complaint tells us, Julia called, inquired after his health, and discussed treatment options. This is not the actions of a reckless and malicious and...
But that all happened before the phone call.
That happened before, but we look at the complaint as a whole. We look at the complaint as a whole, and we don't necessarily pull out every individual allegation. We look at her behavior with this family as a whole. Even if this court, however, disagrees with me on everything that I've said and accepts my opponent's version, there's a second immunity statute I'd like to just briefly to address, 230551. It protects the guidance counselor individually as well as the district, because this law protects mental health professionals and the organizations that employ them. It's a critical law giving immunity because without it, no one would want to work with our most sensitive and needy populations. School guidance counselors, if they're going to be held responsible for children's acts of violence towards themselves or others, no one's going to want to work as a guidance counselor in the schools. And that's why this exception, this immunity is very broad, and there's only one exception. The exception has 3 parts. All 3 parts have to be met. And we stop at the very first element. The first element is that the client or other knowledgeable person has to communicate an explicit and imminent threat of physical harm. The client, the student did not. There's no allegation that he said anything to the counselor. And knowledgeable person, my opponent just argued that Jane Doe was a knowledgeable person, but at the same time, he's arguing that she knew about what the child told her. He's not arguing that she is a knowledgeable person within the meaning of the statute, and that's an immediate family member who knows the client personally. My opponent just told us that this woman didn't know who the parents were of this child. She did not know him personally. Perhaps she spoke to him once. The more important point is that there's no allegation of an explicit and imminent threat of physical harm. This woman alleged that this child was generally suicidal, and 3.7% of the population, a huge number of people, have suicidal thoughts. Only 1/7.
Wait a second. How can you divorce the fact that this child was cutting himself, that he had been in treatment? You just talked about all those things. So how are you equating him to the general public? There's specific knowledge here about this child and about his fragile mental condition.
Certainly, but if it stands to reason that if Jane Doe thought this was an imminent threat of harm, serious physical harm, she would have called the police. She would have called 911.
Well,
Now,
is that what you argue in summary judgment?
I could definitely argue that on summary judgment. However, there's an allegation here that she just spoke to the guidance counselor, there's no claim here that she called 911, and this is what this statute protects. It protects school employees, and specifically in the third element, it tells us that
You need to wrap up. You're out of time, actually.
Thank you very much. I appreciate it.
Thank you both for your presentations, both sides. I should take your presentations to the court. The court will take the matter under advisement. A written and will be sent to both sides. And you can check on the Supreme Court website now. Thank you.